If you are in debt right now, this video is for you. This is essentially what happens when you ask banks and financial institutions the correct questions. It's a case study on debt discharge and credit repair. This living man shows personal first-hand experience dealing with banks and third-party interlopers like debt collection agencies and lawyers, and how to handle letters that they send to you. He gives us a bit of history on money, the banking system, and lending practices in general, known as usury. See the Science of Shylock for reference. Now, all of this, I won't go into it, but if you've been in the game for a minute, none of that information will be new to you, but it is interesting to hear someone talk about it to help you understand why someone like myself chooses to ask these financial institutions a few simple questions. If they cannot or are unwilling to provide the answers to the questions, like I want to see the original debt instrument, we must assume that they either do not have the debt instrument in their possession or it doesn't even exist. Either way, without the debt instrument, a valid contract, and a claimant, there is no debt, therefore there is no claim. Let's get into it. Here, the first letter sent from Mr. X to the financial institution just states, I would like to make arrangements to settle the account. Please send me the statement and written confirmation from you that you will accept my payment in full in return for the original debt instrument in its original form. Simple request. Their standard response here is to simply send you a picture of a statement, thinking that that constitutes the debt instrument. However, we know equity law, contract law, this doesn't constitute a original debt instrument. We hit them back with another letter. Thank you for your correspondence. It is apparent that you have overlooked or ignored my request for written confirmation of payment in full in return for the debt instrument. Unless I receive your written confirmation that you will do so, I must conclude that you are either unable or unwilling to provide the debt instrument. Therefore, I will consider the matter between us legally and financially settled. We say, as we have had no reply over the 3 weeks, it has become apparent that you have ignored my request. Unless I receive your written confirmation that you will accept payment in full in return for the original debt instrument in its original form, we must conclude that you are either unwilling or unable to comply, and thereafter consider the matter between us financially and legally settled. Little caveat. Now the bank knows exactly what I'm requesting, and they know that they are obligated to produce the instrument of indebtedness in its original form upon full, and then they will then try and use that as evidence in court. However, a sui juris man like myself or woman would know that we don't ever step into a court unless we want to. And he's noted here, we'll never go to court because there is no dispute. We simply want to settle the account and they are dishonoring our will. This has got to do with equity law, acting in honor. We are acting in honor, always accepting with conditional acceptances. However, they are acting in dishonor by not acknowledging and not responding to our requests. They've sent a response here, still again signed in blue ink, so there is a living man on the other end taking responsibility for the communications. In response to each letter, we've tried to contact you via the phone. To date, we've not had a response. Please advise if you have a new number. We need to discuss your query with you over the phone. We will not do such a thing. Again, they hit us with a scary letter that they state some scary stuff here. They talk about cancelling the alleged have with them within 14 days of receiving this letter. They give him a few demands talking about debt recovery, third-party interlopers, whatever. You can pause to read it here if you want. This letter was lost, but it proves how close we are as the human being, well, we call him the living man or woman, who sent the original letter has gone AWOL, and we'll note that it is now signed by a black signature. It's a dead entity. We don't have a name, just says manager card operations. A computer has installed that signature on the document. No one actually wrote it. Here they send you a letter of demand stating they want the full amount. Further interest and charges will accrue, blah, blah, blah. 14 days to settle it. This funny bastard has said in his response, I have received your letter dated 11th of February where you state you have left messages for me on the phone. I have currently listed with you. This is an old number of mine. Please update your records to show that I do not currently have a telephone number. After this, they hit him with a letter from Gibson and Sheet Lawyers. We've been instructed that you owe $12,000, which is the amount due on the above accounts. Despite previous demands, you have failed to pay. Unless the National Bank receives XYZ amount, we will seek further instructions for the recovery of this debt without further notice. This may include issuing of legal proceedings against you. We recommend taking legal advice about the debt as there are serious consequences. He's called them up on a bit of funny business there where they've actually entered the wrong card number, and he's pulled them up on that, so hilarious. Important part is down the bottom. If this is the case, it is apparent you are acting on the presumption that some relationship that you may have with the National Bank is in some way related to me. I'm not party to this implied relationship that you have, either directly or indirectly or by means of tacit consent. Google that term. Accordingly, I do not understand exactly how I'm supposed to respond to you, as I am unaware of any contractual relationship between us. As a courtesy, and because you may find it helpful, I have attached recent correspondence between myself and the National Bank, where I have repeatedly offered to settle the matter between myself and the National Bank. The lawyers have also failed, and the letter is forwarded to the bank, who know they do not have a legal leg to stand on. They resort to quoting the Code of Banking Practice, which is an internal banking industry document governing their behaviour, not ours, which is hilarious. Do not respond, he states. National Bank has contacted a lawyer. The lawyers contacted the alleged party, and the lawyers have immediately sent that letter to National Bank, where they have responded with this. The terms and conditions for this account that you state you accepted as soon as you either agreed in writing to the conditions, signed, or used your card. These conditions form a legal contract between you and I. In this contract, you agreed to pay. Any responses from you have been by mail only. And in these letters, you state you consider the matter legally and financially settled. Ha. The bank does not consider this matter legally nor financially settled, as in accordance with Section 5.1F of the Code of Banking Practice. The third-party interlopers have now been engaged. Excellent. The debt collectors get involved. They whack a fee on top and hope that we will pay. However, we will not. But we conditionally accept. Debt collection agency, it's gone from 12 to 14K. Payment of this amount, along with the current balance, is required to settle your liability. Should you be aware, further costs may be incurred throughout the process. They have now responded with a very well-worded letter, I might add. You are acting on the presumption that some relationship you may have with the National Bank is in some way related to me, which, if such presumption is the case, I confirm that I am not a party to this implied contract, relationship, you have with the National Bank, either directly, indirectly, or by means of tacit consent. And accordingly, I do not understand how to respond to you in us. 2. You have entered into this contractual relationship inclusive of evidence of consideration paid to or agreed to be paid to the National Bank, which contractual relationship has caused you to become the legal holder in due course of the alleged debt between Mr. XYZ and the bank. If indeed you have entered into such contractual relationship with the National Bank as set forth in Clause 2 above, then I hereby confirm that I accept your offer to reduce the amount of the alleged obligation from $12,000 to $0. And I confirm that I would like to make arrangements for settlement of the above referenced matter immediately upon you providing me with your written and legally binding assurance that you will accept payment in return for the debt instrument in its original form, that you must now be holding in pursuant to the aforesaid contractual arrangement between you and the National Bank. So, they have replied with a letter confirming that the contract that they are acting upon is one which they have made with the National Bank, and we are not party to this contract, so we have nothing to fear, and they highlight as much in it. So story here, so if John makes a contract with Mark to collect $15,000 off Jimmy, does Jimmy have to give Mark the $15,000? No, unless Mark can prove that Jimmy owes $15,000 to John. This is why we are at this position. A Corp have responded, we refer to your recent correspondence. Our involvement in the matter is at the request of our client in providing monies owed to them by you on their behalf. A contract exists between this office and our client authorizing Bay Corp to collect its debts on their behalf. As the contractual relationship is between Bay Corp and the National Bank is confidential, you are not entitled to a copy of it. Your claim that Bay Corp is not entitled to contact you is therefore incorrect. This is where I find it gets interesting. It is likely that the collection agency will list your default against your good name in your National Credit Reporting Agency. This is the only real threat they have now. Be sure to check if they have tarnished your record and let them know that it is the bank who is in default, not you. As presumed, shown by the image below, the default has been listed, the score is now 392 and is close to the red, but they state down the bottom, all we need to do is forward our correspondence with the banks and their minions to Veda Advantage and have them investigate the matter as follows. Dear XYZ, thank you for your reply. Attached is all my correspondence with the National Bank, who I am apparently owed $12,000 to. As you will see, I have offered on numerous occasions to settle the amount with the insurance in writing that they will provide me with the original instrument of debt in its original form. You'll see in my letters, the National Bank on every occasion has overlooked or ignored my request to exercise equity in redemption, and by refusing to acknowledge that right, they have refused to accept payment in the process. That settled the matter legally and financially. I gave them another 10 days to respond, which they did not. This settled the matter once and for all on the 15th. I have since been harassed by lawyers and third-party interlopers known as Baycorp, who I have no contractual relationship with. They have no knowledge of the matter between myself and the National Bank and no business whatsoever harassing me. I have kindly offered both these agencies settlement in full on the amount owing upon their assurances in writing that they will provide me the original debt instrument in its original form, which binds myself to these agencies. Neither have offered to accept payment from me on either occasion. To date, neither the National Bank, the lawyers, or Baycorp have made any reference to the original instrument of indebtedness in any of their correspondence. It seems to me that there is no original instrument of indebtedness in existence, which again settles the matter legally and financially. I would appreciate it if you would review my documentation and obtain a statement of facts from the National Bank outlining exactly why they cannot produce the original instrument of indebtedness and why they have had their lawyers harass me for a non-existent debt, which they have referred this non-existent debt to a debt collection agencies. Their reply was emailed back where they say, RE, your credit file information. Thank you for your patience. Please be advised that having further reviewed the information provided to date, we are satisfied that a form of dispute was raised prior to the default being listed by Baycorp on behalf of the National Bank. For this reason, the default has been removed from your credit file and Baycorp have been informed of our decision. Please be aware that other parties concerned, Baycorp and the National Bank, may choose to pursue you for the outstanding balance as they still believe that you owe this debt and may pursue you via other means, such as disputes tribunal and the courts. Please find attached an amended copy of your credit file and a copy of your rights explained brochure. We trust this clarifies our position on the matter. And here below is a freshly amended credit report on file at Veda Advantage showing 0 defaults and a score of 647, back up in the green. Boom, there it is. Furthermore to all this, we have sent the following letter to the National Bank requesting more information and they will not respond. I last heard from you where you discontinued your claim. It appears from your letter that you are unable to produce the original instrument that created the liability you seek to enforce. If you in fact still maintain that the debt is owed, I am not opposed to assisting you in properly settling the matter. However, to ensure proper settlement, I will require discovery of information that you are privy to. As banks no longer deal in silver and gold, I understand there to be no money sitting in your vaults that you lent to me when the transaction took place using the credit card in question. I understand instead that you were able to issue and extinguish credit in accordance with your arrangement with the Reserve Bank of New Zealand. If you have borrowed funds from any other source, then please disclose the identity of the lending party to me without delay. If you are unable to return the original instrument of indebtedness to me because you had to forward it to the Reserve Bank in order to issue the credit in the name of the credit card, then please disclose to me the identity of the person within the Reserve Bank who received the instrument, and I will take up the matter of its return with that person, as well as commence the settlement process on your account. If it is a different person within the Reserve Bank who facilitates the issuing of the credit that was used for the transaction on the above credit card, then please forward the details of that person to me as well, so I may learn from them the exact source of the credit you are claiming now needs to be paid. As it is not my intention to injure anyone, I am eager to resolve this matter by determining the identity of the party from whom the lent funds originated. Baycorp confirmed in writing that the original instrument of indebtedness no longer exists. Please find enclosed a copy of details relating to this account. The balance is 14K. The National Bank has advised that as the original account was opened in 1998, a copy of the original application form is no longer held. However, this does not negate the fact that it was your account and you have confirmed this in your letter to the bank. If there are any matters you wish to raise in relation to this matter, please contact us immediately and we will resume collection action against you if a payment is not made within 10 days of this letter. They've responded again. Mr. XYZ have received communications from your company. I understand it to be you who's accountable for actioning these letters. None of these communications has any evidence been provided confirming Mr. XYZ is party to any contractual agreement with Baycorp Ltd or your client, the National Bank. You have unsuccessfully attempted to tarnish Mr. XYZ's credit rating with Veda Advantage and continue to send threatening letters in the post. Take note that if Mr. XYZ receives any more unwarranted communication in any form from you or the company who controls you, I will take the appropriate measures to ensure that you are personally held accountable for the harassment. If it is not you who is accountable for the harassment, then please provide the name of the person or the position of the person within Baycorp who is. Boom. Let me know if you want to hear about any specific thing that we spoke about here. Fuck the banks.